Section 47 is a very important provision in the Civil Procedure Code. It speaks about the wide power of the executing court to determine all questions which arise after the decree. What is the nature and scope of this provision? Here, exclusive jurisdiction has been conferred on the executing court in respect of all matters relating to execution, discharge or satisfaction of a decree which arise between the parties or their representatives. That means, after the passing of the decree, whatever questions relating to the execution, discharge or satisfaction of a decree arise between the parties or their representatives, only the executing court has the power to decide. Once the suit is decreed, then no other court but the executing court only can determine the questions which arise subsequent to the passing of the decree, and the parties need not file a separate suit because under section 47 clearly it says that filing of a separate suit is barred. Section 47 subclause 1 says that all questions which arise between the parties to the suit in which the decree was passed and or their representatives relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. This means that between the parties to the suit, the question should have arisen and that question should be relating to the execution, discharge or satisfaction of the decree, and they shall not file a separate suit to decide those questions. Now here, who is the representative of the party? Section 47 subclause 3 says that the question to decide whether the person is a representative of the party to the suit or not shall also be a question which is determined by the executing court only. Explanation number 1 to the provision says that a plaintiff whose suit has been dismissed is also a party to the suit, and a defendant against whom a suit has been dismissed is also a party to the suit. Then explanation 2a says that a purchaser of a property at a sale, because after the execution takes place and a property is sold in execution, a purchaser who purchases the property, he is also deemed to be a party to the suit in which the decree is passed. So any question relating to the purchaser, that is, for example, all questions which relate to delivery of possession of such property to the purchaser or his representative, they are also deemed to be the questions relating to the execution, discharge or satisfaction of the decree within the meaning of this section according to explanation 2b. The object of this particular provision is to provide a cheap and expeditious remedy to the parties so that they need not file a separate suit and they can determine all the questions which arise subsequently in execution proceedings itself. Secondly, they can obtain adjudication of those questions relating to execution without bearing unnecessary expenses or without any unnecessary delay which may be caused if they file a fresh trial or if they file a fresh suit for the purpose. Now, what are the conditions for this section to apply? First of all, the question must be one which is arising between the parties to the suit or their representatives, that is the suit in which the decree was passed. Secondly, it must relate to the execution, discharge or satisfaction of the decree. These two conditions must be satisfied cumulatively. This was stated in Merla Ramanna versus Nalaparaju 1956 by the Supreme Court. Then in Sundardas versus Bishandas, the court said that parties or their representatives does not mean de facto parties on record like plaintiff or defendant who are the parties on record in the suit, but it means the parties who are opposing each other. For example, if it is a partition suit, sometimes the co-defendants do not oppose the plaintiff. So, if there are questions between the co-defendants may be opposing each other. Those questions are also questions which fall within section 47, that is between the parties to the suit. This was stated again in Sundardas versus Bishandas. In Samhut Rai versus Sambharan Rai, the Patna High Court said that where a person is or not party to the suit, whether he is a party to the suit or he is not a party to the suit, in this case it held that whether a person is or not a party to the suit should be decided not on the basis of whether he is a party to the decree, but whether he is a party to the suit in which the decree is passed. So, in the original suit, whoever was the party to the suit, he only can raise questions before the court under section 47. Now, what is the meaning of execution, discharge or satisfaction of a decree? The meaning of this, according to several cases decided by the Supreme Court, is that the question of executability or non-executability of a decree is the question should be decided by the executing court only. So, which are these questions? Let us look into some examples. For example, whether a decree is executable or not. This is a question which arises in execution. Whether a property is liable to be sold in execution or whether it is not liable to be sold in execution, that is a question that can also be decided under section 47. Whether the decree is fully satisfied or it is not fully satisfied. This is also something which is subsequent to the decree. Whether an application to set aside sale is maintainable under this provision, that also can be decided. Whether a particular property is included in the decree or not, or whether the party is entitled to restitution of property or he is not entitled to restitution of property, whether the decree has been adjusted outside the court or not. Such questions which deal with this execution of the decree, discharge of the decree or satisfaction of the decree itself are questions which can be decided under section 47. Now, which are not the questions which relate to execution, discharge or satisfaction of the decree. For example, whether a decree is fraudulent or collusive. This question cannot be decided by the executing court because whether it is fraudulent or collusive goes behind the decree. So, they have to look into the facts which come in the suit which was decided before the decree was passed. That cannot be decided by the executing court. Secondly, whether the court has territorial jurisdiction to pass a decree or whether it has pecuniary jurisdiction to pass a decree. This also is not a question which can be decided by the executing court because it again relates back, that is before the decree. An order reopening the decree or refusing to reopen a decree. Suppose a court refuses to reopen a decree. There again it is something which does not relate to execution or discharge of the decree. So, it cannot be decided under section 47. A question relating to what are the amount of mean profits to be granted, whether the mean profits granted by the court is proper or not. This again goes to the facts which relate to the suit, that is the original suit, which should be decided by that court or in an appellate court. It cannot be decided by the executing court under section 47. So, such questions which do not relate to the actual execution of the decree cannot be questions relating to section 47, they cannot be decided. Then, what are the powers and duties of the executing court according to section 47? In CF Angadi versus YS Hiranaya, the Supreme Court held that the executing court can decide all questions arising subsequent to the passing of the decree, not before. It cannot go behind the decree and decide questions which the earlier court or which the original court would have decided. In Bhavan Vaja versus Solanki Hanuji Khodaji, the court said that where the terms of the decree are not clear, they are vague or they are ambiguous, then the executing court has a power or it has a duty to interpret the decree in such a manner that it should give the meaning which was intended by the court which passed the decree. This was stated in this case. Then whether there is an appeal for an order passed under section 47. Now, after the Amendment Act of 1976, where there was an amendment made relating to the appeal provisions, the determination of any question under section 47 is now no longer deemed to be a decree. Therefore, such question which has been determined by the court cannot be appealable under section 96 or section 100 of the Civil Procedure Code. So, to summarize these provisions, we can say that section 47 is one of the most important provisions of the code relating to execution because it confers wide powers on the executing court to deal with all matters relating to execution, discharge or satisfaction of a decree, basically between the parties or their representatives to the suit. It cannot be relating to any other matters, but the executing court can decide relating to the execution of the decree only. It cannot go behind the decree and decide any matters which would have been looked into by the original suit or by the court in the original suit. I hope you have learned something from this video. If you have liked it, please share it with anyone who you think would be interested. Please leave your comments and I would be happy to reply to them. Do subscribe to get more information on everyday law and legal studies. Thank you.